Fantastic. Well, thank you all for joining. It's an honor for us to have you. It's a delight for us to be some complement to your entrepreneurial journey. And whether you are a student, whether you work for a company, whether you're already an entrepreneur, you're all entrepreneurs, and you have to think of yourself as entrepreneurs. Our job here is to provide you with more knowledge. Knowledge is important for entrepreneurship. So let me say very briefly about the bootcamp, and this will set the foundation for Nathan. The bootcamp is an entrepreneurship training program at MIT. It is extremely intensive, and our goal is to impart a practical and comprehensive toolkit for you in new venture creation. It is aimed for entrepreneurs who look to start their own ventures, as well as entrepreneurs who innovate within existing companies. Right? Uh, Both of this, and you can easily put yourself into one group of people or another. Currently, Andrew and I, we are entrepreneurs within MIT. We work for MIT, but we both consider ourselves as entrepreneurs. And together we are developing the bootcamps program here at the institute. And if if you care about understanding what are the sets of approaches, frameworks, behaviors, mindsets, and attitudes that are essential for optimizing your success as an entrepreneur and for helping you achieve extraordinary impact, the bootcamp is the right place for you. Now, the secret sauce of the bootcamp are the bootcamp coaches. The bootcamp coaches in the bootcamp work around the clock with you, providing feedback that we give the directive to coaches to kind of break down your ideas, but then build you back up. The goal is to rigorously engage with the subject matter at hand, but in a way that elevates you, that inspires you, that propels you to do better and to do more. Can you?
Erdine, you're having audio issues, I
Oh,
feel.
oh. Let's see. Maybe it's. I'm using this mic as an attachment to the.
I can hear you right now.
Can ever can everyone hear me? Can everyone hear me now? No?
I can hear you fine.
Great. Okay. And so the goal of this e-seminar, it is to talk about patents. A lot of entrepreneurs ask the question of, do I need a patent? But at the same time, it is also an experience for you in understanding the kinds of coaches that we bring to the bootcamp, the caliber of the coaches that will be working with you and providing you very rigorous feedback and mentorship throughout the journey. So I'm going to stop here. I think it gives you a good foundation of what the bootcamp is. And Nate, take it away. I'm sorry. Let me briefly share a few words about Nathan. Nathan and I were actually classmates at MIT, but he was a much more intelligent classmate than I was. In fact, I credit my ability to graduate from MIT to Nathan. I graduated from MIT with a 4.0 GPA. And before you are impressed with this, you should know that MIT GPA is in a 5-point scale. So I was far away from the standard of achievement, but Nathan was right there. He has a PhD in chemical engineering from MIT, from the lab of Karen Gleason, as well as an MBA from the Sloan School. Currently, he is a consultant with the Global Economic Consultancy Analysis Group, which is the top of the line firm in this particular field. And he engages a lot in issues that have to do with patent litigation, which is where he really can bring his expertise here today. And I owe to Nathan a big aspect of my entrepreneurial life. Nathan actually introduced me to his lab mate and friend in chemical engineering, Miles Barr, with whom I eventually co-founded a company called Ubiquitous Energy. And actually Nathan played a consequential role with that company in the early goings of it. So I owe a lot to Nathan, and it's fantastic to have him as part of the bootcamp program. So Nate, please.
Thank you, Nader. And I appreciate everyone making it out here today, virtually from wherever you are in the world. The goal here, I'm going to get into a lot of specifics about things that relate directly to the US patent system, but I want everyone here to understand that these takeaways will largely apply to any intellectual property protection with patents across the world. And so while my specific examples relate to the US patent system where I'm most familiar, you can rest assured that the key insights and takeaways would be relevant to you in your particular country. Or in fact, if you want to patent an idea and take it to the United States, the insights that I'll share will be relevant to that mindset. But briefly, I want to, pardon me one moment here while I clean up my shop. Okay. I want to start with a disclaimer. I am not an attorney. I am not a lawyer. And so if you have specific legal questions, unfortunately, I can't help you there. I'm going to speak as best I can from my experience as a consultant who helps companies determine how to best monetize their intellectual property. And in fact, in patent litigation, does just that. We help them obtain damages awards for patent infringement. And so a lot of what I'll say today is based on my experience, both as an engineer in the process of obtaining patents, as well as having consulted with startups and large companies on intellectual property strategies and monetization strategies. So the goals for today, I would consider today a success if each and every one of you leaves today understanding what patents can and cannot do. The other goals involve understanding what are the aspects of patents that make them valuable, and to hopefully get you a sense of what the true costs are and the trade-off in patent value, what the true costs are of patent ownership. After we have a solid basis for understanding what patents are, what they could do for you, and how much they really cost, we've seen the good, bad, and the ugly, then we can really begin to answer the questions of when it actually makes sense to pursue a patent strategy. And finally, we'll close with discussing what are available alternatives to patents should you decide that pursuing a patent isn't really for you. So we'll start with a simple question. Why are patents useful? Well, patents let you sue for infringement. That's it. What does that mean? Patents are a legal tool that allow you to sue someone. They let you take an innovation, set it in stone, and obtain a legal monopoly whereby you can sue someone for using your invention without authorization. And that's really it. A patent is a ticket to court, meaning everything that relates to value, costs, and strategic considerations of the patent involve that fundamental aspect of how patents exist and what they're used for. However, the implications can be really profound for entrepreneurs because this very aspect of being able to take someone to court for using your idea provides multiple strategic options for entrepreneurs that are considering intellectual property protection. And when you think about whether a patent strategy is the right decision for you to make, you have to think about that decision in light of all the costs, all the benefits, and ancillary strategic aspects of patent ownership. So we're going to jump right in. What can patents do for you? Patents are exclusionary rights. So what it means is patents do not let you do something. They keep others from doing something. It's an asset, just like any other asset. They could be bought, they could be sold, they could be transferred. Sorry, one moment here. I have these pop-up screens that are blocking my view of my slides. Okay, here we go. So as I mentioned, patents are exclusionary rights. They can be bought, sold, and transferred. They prevent others from making an offering to sell or importing inventions. They do not let you do something. They keep others from doing something. And importantly, patents are territorial rights, meaning if you want to obtain patent protection in a different country, say Canada, well, then you must obtain a patent in Canada. If you want to obtain patent protection in Mexico, then you must obtain a patent in Mexico. Patents must be obtained for every territory where an inventor wants protection. And once you have this protection, once you've obtained a patent, you have the right to sue an infringer. An infringer is someone who is using your patent and the idea in the patent without authorization. You can sue them in the territory where the patent is valid, while the patent is valid. And And I'll get a little more into a little more detail about the concept of infringement and what constitutes infringement later. But I think right now it's important to understand what it is that patents can actually do, by contrast, what they cannot do. So why does a patent system exist? Why does this system exist where someone can get a legal monopoly? Well, the goal of patents are to encourage innovation and investment in the world. And you do so by providing the world, as the inventor, the disclosure of your invention. So it's a tit for tat. Let's say United States Patent Office awards you a patent. In exchange, you're required to provide the U.S. Patent Office with a full disclosure of your invention so that it could be disseminated to the public. And as a result of that, the U.S. government would give you a legal monopoly for typically about 20 years in the United States that would exclude anyone else from practicing your invention. And what's great about it is that it really encourages open innovation. Patents allow you to put your idea out there so that someone else can take what you've done and improve upon it. That's by contrast to trade secrets, which I'll discuss later, in which someone is essentially operating in the dark, doing innovations in the dark so that only they can benefit. There are certainly strategic reasons for pursuing trade secrets, which we'll discuss later. But to understand why the patent system exists, it's in essence to discourage covert innovation through trade secrets. And of course, this all sounds too good to be true, right? Remember, you have to disclose your invention. And so the trade-off is that not only do you have to disclose your invention to everyone in the public for them to be able to copy your invention, but you must also disclose the best method for implementing the invention. You can't hide the best method. In fact, your patent can be invalidated if it's later determined that you've failed to disclose the best implementation or method for using your invention in the patent application. So I mentioned some of the key benefits of patent ownership earlier today, but just to summarize what the key benefits to patent ownership are for entrepreneurs and companies alike, big companies alike, is patents give you a competitive edge. They keep your competitors from creating and utilizing what you believe to be the best products and processes. If you come up with a great innovation and patent it, suddenly your competitor cannot use your invention unless they're able to design around it in such a way that it does not infringe on your patent. Patents are a potential revenue stream. There are some companies that choose only to license the right to their patent. As I mentioned, it's an asset that you can transfer or assign to someone else. And rather than deal with the risk of manufacturing or the risk of having to produce the product themselves. And that's a perfectly viable business model. And patents give you the right to do so and obtain licensing revenue. As I'll discuss later, that's not a common strategic option for companies, but certainly if that's something you're interested in doing, it is very much something that you can monetize through licensing alone. Patents also provide negotiation leverage. There's this concept of cross-licensing whereby I have patents for a technology, my competitor has patents for a similar product, but it's a different technology. I might need to use my competitor's patents in order to sell my product. My competitor might need to use my patents to sell their product. So patents exist also as a form of currency whereby you can exchange the rights to use each other's patents, even with competitors, as a cross-license. I'm sure none of you here are surprised to learn that Apple, for example, has to license patents from Samsung and vice versa in order to sell competing phones. It's a very common negotiation tool, particularly in the telecom space and other medical devices, whereby there are multiple patents required in order to practice a product. Another interesting aspect of patent ownership value has to do with the risk shifting to competitors. And so when you have patents that are so well crafted that your competitors cannot really figure out if they're infringing or not, you've created operational uncertainty for them. Your competitors suddenly have to tiptoe around broken glass to make sure that they don't cut themselves, because what's worse than finding out you've infringed a patent after you've made $5 billion of sales? It's a pretty bad deal when suddenly your competitors are taking you to court, telling the court, hey, I have this patent for this technology. My competitor's been selling this technology for 4 years, has made all these sales. I've provided them plenty of notification that they might be infringing my patent, and they've chosen not to do anything about it, pay me some money. And more often than not, when the infringement is clear and the intention of the competitor was clear to infringe, the courts will do the right thing and force the competitors to pay out. And so that is, I think, in a nutshell, the key benefits of patent ownership. However, with all of these benefits come the trade-offs. Of course, patents, as I mentioned, are exclusionary rights, and they do not guarantee the freedom to operate. And the freedom to operate is something that any startup really values, right? You don't want to feel that there's a stranglehold over you before you've ever made your first sale, because you're not sure if you're infringing on someone else's patents. And so it is, in fact, true that you can be prevented from practicing your own patent if you're infringing on someone else's. And so to give you an example, you see these Venn diagrams here at the bottom. Here we show that I have my patent. The scope of inventive technology embodied in the subject patent is represented by this circle. Here is the product that I am selling. The scope of the inventive technology embodied in the product overlaps with my technology that's patented. However, it may also overlap with the technology embodied in others' patents, and I cannot sell this product without infringing on others' patents. When that happens, that can lead to startups having to battle lawsuits against competitors or others in the early stages, when having liquidity is most crucial and they're most resource constrained. And so it's important at the early stages, whether or not you choose to pursue a patent strategy as part of your startups, that you undertake at the very least a topical freedom to operate analysis. If you have some money to invest here, I think it's valuable. It doesn't have to be a ton of money. You can pay a patent agent or an attorney and negotiate a fixed fee freedom to operate analysis, so that they could take a look at the operational landscape of the patents in your industry and determine whether it's safe for you to practice your idea without infringing. And if so, that they can notify you where there might be potential pitfalls. Of course, they'll be very strategic about how they present you that information, because once all that information is in writing, it can lead to problems down the line if it's not properly handled. And that's why I recommend you pursue someone, if you do undertake a freedom to operate analysis, that you pay someone who's skilled in that space, has some legal experience, or is aware of the legal ramifications of putting stuff in writing at an early stage that can be used against you in court later, should you decide that you're not infringing and then it turns out you do infringe. And so that's just a little cautionary tale here. Here's another example of freedom to operate and how you can find yourself under a stranglehold of someone else's patents. And so here we have my innovative cup, Nathan's innovative cup. So on the left, we have Erdine's cup. Erdine has a patent that claims a cup comprising a red exterior with a white interior. As you can see, Erdine has a really exciting and awesome technology at his disposal here to create a container that can hold liquids and all sorts of goodies, and it's red on the outside and white on the inside. I see this patent and get so excited about it, and I then innovate. I take Erdine's patent and he discloses it publicly, and I innovate. I create a cup comprising a red exterior, a white interior, and a handle. This handle allows you to hold the cup when there's hot liquids inside and prevents you from spilling on yourself. Unfortunately, I can't sell my cup without infringing on Erdine's patents. And if I do, Erdine can sue me. And so before I sell my cup, I need to understand, is Erdine willing to license his patent to me? And if he's not, is there a way that I could design my cup without infringing Erdine's patent? And so that's, again, where it becomes useful to have people that know about a little bit about patent law within the circle of advisors for your startups, just to understand whether or not you're treading in a very kind of nebulous area where you may or may not be infringing on someone else's patents. And if you are potentially infringing on someone's patents, depending on how innovative that person's patents are, can you design around it? You'll find out later that some of the most valuable patents are those patents that completely block competitors from improving upon their patent. And in fact, they're referred to as blocking patents for that very reason. And we'll get into more detail on that later. So I gave you an example of Radine's patent and my patent, and I mentioned there that our patent claims something. Just so everyone here knows, patents are very lengthy documents with a lot of words and a very legal sounding language and a lot of really technical jargon in certain places, all strategic, all important, all valuable. However, what's really important to patents are this concept of claims. Claims are the things that give patents value. Depending on how good your claims are, that will ultimately determine how valuable your patents are. And so to understand how that works is first better to understand how it is that patents are constructed. There are basically two key components to a patent. They're the claims, which, as I mentioned, are the most important part of a patent. Claims are essentially the invention. And then there's a specification. The specification is just about everything else. That provides a detailed a description of what the invention is, how to make and use it. It's that example that I described earlier, which is the best mode for executing the invention. And it provides figures, drawings, and other visual aids. And the purpose behind the specification beyond quote unquote teaching the patent to the world is to provide context for the claims. When you actually take someone to court to sue, the judges look at the claims and interpret the claims in light of the specification, because the specification is intended to be directed towards the audience of those individuals that are skilled in the art, and the art relates to the field of your invention. And so the claims are extremely valuable because they are the invention, and the specification provides a bit more context for the claims. But at the end of the day, it's the judges in the courts that determine and how to interpret the claims so that they can decide whether or not you've infringed the patent. Briefly, here's a couple examples of claims and how they work. And here we have what's known as an independent claim. This independent claim teaches a pot comprising a compartment for carrying liquids with a plurality of spouts extending from the compartment. And basically, it's a tea kettle with two spouts. And the scope of the claim, we'll call it, is A and B. So this independent claim is very broad and then becomes more specific by adding modifications to that independent claim with what are referred to as dependent claims. Part of a patenting strategy is to come up with the right combination of independent and dependent claims such that you create the largest scope for protection for your invention. There are some cost benefits as well. Some patent offices charge per claim, and they charge their fees per claim. And so when you use dependent claims as offshoots of the independent claims, it can actually reduce the total cost because, as I mentioned, they charge per, when I say per claim, I mean independent claim. They charge per independent claim, and dependent claims allow you to expand on the independent claim and expand the scope of your patent. And to give you an example of how patent claims are valuable to a patent and teaching the invention, I'm going to give you one example of how a patent can be used, how patent claims can be used to establish whether a competitor's products are infringing. Here we have the patent claim on the left-hand side, which teaches a fuzzy structure that fetches a ball comprising a tail, at least one wet nose, and a plurality of legs. So basically, you've invented a dog. As you'll later find out, you're not allowed to invent dogs because it's a natural thing. You can't invent things that exist naturally in the world. But in this example, here we have a fuzzy structure that fetches a ball comprising a tail, at least one wet nose, and a plurality of legs. What we have here is a table which is referred to as a claim chart, where you take the components of a claim and you break them out and you compare them to the accused invention. And if each accused product reads on every single element of the claim, essentially the patent's been infringed. And you can see that you have the fuzzy structure on the right, and then there's a tail. You can see the tail. There's at least one wet nose. There's one wet nose. And then there's a plurality of legs. We have 4 legs, a plurality. Okay, so at this point, you now have a sense for A, what patents do, B, what patents don't do, C, how patents work, and D, what gives them value. Now we're going to get into a little bit of the kind of reality check on what patents, what the reality is of patent ownership. And so first off, patents can take a long time to issue. So despite these benefits of being able to monetize your patent and make a lot of money and block out competitors. There is a reality to it. You could be sitting in your hands for a while waiting for your patent. So to give you an idea of how long and slow the process is, it takes on average 18 months to receive your initial answer for your application. And this is in the US Patent Office. And this is even if your application is perfect. Typically, they'll come back to you and say, well, your patent's a little too broad. It's not specific enough. In its current form, you are overlapping with other existing art. And rather than reject your patent, let's revisit how you phrase your claims. And so each revision takes approximately 6 months. And so you can imagine after a few rounds of revisions after your disclosure, you could be sitting there waiting a while for your patent to issue. So the takeaway here is that it's really only worth patenting an invention if you view that there's a long-term benefit to its protection. So if your startup is really short-term oriented, if the market is very short-term or ephemeral, a patenting strategy might not be the right thing for you because you might be protecting something down the line that's no longer important, valuable, or relevant in the near term when you need to make money in these early stages of a startup. Additionally, there's no guarantee that your invention will even become issued as a patent, and it's common enough where that's something that's a serious consideration that one must take in mind. And regardless of whether or not your invention is patented, it has to be disclosed publicly in 18 months through the patent office. And so one caveat here is that your invention can be revealed to the public without you obtaining any legal protection. So to give you a sense of how long overall it takes for individuals to obtain a granted patent, it takes anywhere from 3.5 years to 5.5 years in Europe. So 3.5 years in the United States, 5.5 years in Europe. And in other countries, it takes even longer. I know we have people sitting in on this e-seminar from all around the world. And you can see that your country might pop up here. And so depending on where you wish to obtain patent protection, it could take anywhere from 3.5 to 5.5 years. And that's the average. Sometimes it could take more. One of my patents, I believe, took about 6 years for it to finally be granted. And so it's a gamble. Additionally, how you choose to apply for your patent will ultimately affect how long it takes for it to issue. When you want to file for a patent, you file what's known as a provisional application, and that basically puts your invention, puts a timestamp on your invention, and that anyone who invents it after you is not going to get a patent because you've essentially invented it the day you filed your patent application. But when you file your patent application, it's a very lightweight patent, so to speak. It's a placeholder. They give you 12 months following the application to file your non-provisional patent application, which is then ultimately examined by the US Patent Office to determine whether or not they're going to grant the application. However, you can take an alternative approach whereby you file a PCT application with World Intellectual Property Organization, WIPO, which will file your patent with multiple countries of interest. And they have treaties with multiple countries that will basically allow you to kind of do this one application for many patent offices. Ultimately, you have to file with each individual national office that you choose to obtain patent protection with. But going the PCT route extends your filing requirement up to 30 months. That could be both good and bad. If you want patent protection sooner than later, well, going the PCT route might actually delay the issuance of your patent applications in your territories of interest. And so that's another strategic consideration that startups should take in mind, as if you're looking for global patent protection, how you choose to obtain that patent protection might delay you obtaining patent protection should you choose to do so. Then there's the other reality. Obtaining and maintaining a patent can be expensive. It's not just getting the patent, it's keeping the patent that also becomes expensive. And I'm going to give you some examples of what those costs look like. So maintaining a patent in the United States requires that you pay fees every 3.5, 7.5, and 11.5 years after issuance. And patents in the US last typically about 20 years for a utility patent. It's about 15 years for a design patent. But the basic idea here is that you're going to be paying for your patent whether or not you're using it throughout its 20-year life. And so again, if you have a technology or a product that you want to launch in the next month, your lifetime value of your customers is basically going to be realized over the next 2 years. And it probably doesn't make sense to try to obtain a patent that will get you protection in 6 years and you have to pay for it 20 years from now. And so you really have to think about what are the long-term IP strategies at a very early stage to understand whether patent protection, whether it's relevant today, might be relevant later. And there are perfectly good reasons to have a strategy that is both short-term focused and long-term focused. Short-term focused to deal with the realities of a startup, to obtain customers, to obtain early customers, early market traction, so that you could continue to innovate, and then in the long run, you have a long competitive advantage by having these patents. And so there might be perfectly good reasons to obtain patents for long-term strategic protection while you're pursuing a short-term strategy. However, it's that in and of itself is a strategy. And so I encourage each and every one of you to really think about what are my short-term and long-term goals, and does it make sense to pay for a patent throughout its life? Additionally, if you choose to obtain global protection, remember I mentioned that you have to file a patent with each and every patent office, which means you also have to pay for patent protection in each and every patent office. In the US, a simple application can run you anywhere from $25,000 to $35,000. It depends on how complicated your technology is. When it's far more complicated and there's, say, a lot of competition in that space, it could cost anywhere from $60,000 to $80,000 or more. If your patent's very complicated. And the reason for that is because of the prosecution process, where you have to really do your research into what's out there, what you might be infringing on as prior art potentially, how you need to kind of construct your claims in a strategic way to really gain good leverage in the marketplace. And the essentially, the better your patents are at blocking out competitors entirely, the more valuable they are. But in order to do so, you really need to understand the competitive landscape, which is going to increase the early costs when you're drafting the patents. But I mentioned global IP protection. The global IP protection bit is, I think, an important thing to consider. There are some companies that, in order to obtain global protection for their ideas, they'll spend anywhere from $500,000 to $1 million for a single patent over a 20-year period. And again, it's very important to understand what your long-run strategic goals are, and how intellectual property protection fits in there. I'm saying $1 million to protect the patent as if it's a bad thing. There are perfectly good reasons for doing so if that patent is generating hundreds of millions of dollars in incremental revenue compared to your competitors based on selling products, or if it's generating tons of licensing revenue. And so you have to have context for these numbers, of course. But it's still a reality, and the money has to come from somewhere, whether it's your own pockets or your investors' pockets. And so when we're talking dollar amounts in this range, you can now understand why making these intellectual property decisions using as much knowledge as you have about your industry, your product, and your goals becomes very important at the early stages for a startup. There's another element of cost that one must consider: litigating a patent. So I mentioned that patents are essentially a ticket to court. So let's say you have a patent, you've decided patents are for me, I want one, I need one, I'm gonna use it liberally whenever someone tries to copy my product. Well, you have to sue someone in order to gain that leverage. Sometimes you can have your attorneys write them a letter, the infringers a letter, and then they'll stop. And then that's the end of the day. Maybe they'll take on a license with you, but other times competitors are just going to want to fight you in court. And there's a perfectly good reason why they're going to want to fight you in court, because there's a good chance you're going to spend as much money fighting them in court than you'll ever take from them in a judgment. So if you want to recover $1 million or less than $1 million in a judgment, you're going to have to spend about $500,000 in legal fees. And so the reality is it's expensive to litigate patents. Attorneys are expensive, and fighting something in court takes time and money. And if the amount at suit is less than $1 million, well, it probably, given the uncertainty of legal judgments, it probably doesn't make sense with certainty to spend $500,000 to potentially recover $1 million. And so what you find a lot of the times is that companies, when the patents aren't terribly valuable, or the infringement is kind of, I don't know, they may or may not be infringing. It's hard to say. That they'll try to obtain a license for a patent, or they'll offer a license for the patent, or they'll come up with some mutually beneficial arrangement to avoid going to court. But as you can see that for some of these bigger cases where there's greater than $25 million at risk, it probably does make sense to spend $5 million in legal fees, especially if there's a very good chance you can settle for a substantial portion of this amount. And so this all comes down to how big the markets are, how valuable your patents are, and how strong a case you have for infringement. The other costs associated with litigating patents that entrepreneurs never think about is the shifting of risk from the person suing to the person being sued, and how suddenly when you assert your patent against a potential infringer, they now have a legal remedy whereby they can challenge the validity of your patent and essentially invalidate it altogether. And because of all the litigation with patent trolls over the past decade or so, there's been a lot of legislation to help weed out frivolous lawsuits and poorly constructed patents. One of the key things that came out of all of this was the Patent Trials and Appeal Board in the United States, which allows you, a potential infringer who's accused of infringing someone's patent, to pay anywhere from $250,000 to $500,000 to challenge the validity of the patent altogether. And as you could see, the statistics aren't very favorable for people that are challenged, at the TAB patent owners that are challenged on average have anywhere from one out of every 4 claims denied, meaning that if you're asserting 4 claims against a potential infringer, on average, if they've challenged it at the PTAB, one of those claims is completely invalidated per patent. And so if that's a dependent claim, or independent claim rather, then suddenly your ability to sue someone for infringement has been severely squeezed and limited. And so that's something that you need to consider when you own a patent. Just because you've sued someone doesn't mean your patent is valid. And your patent, the validity of your patent could be challenged. And nowadays, there's a greater than zero, a substantially greater than zero chance that it will be invalidated. So now we've talked about what patents are, what they could do for you, how they work, what they cost, how, and time and money. Now, there's some positive sides to it, but beyond just the monetary benefit of it. If you're an entrepreneur or a startup, you're constantly asking yourself these questions of whether or not it makes sense to obtain a patent in order to look good for venture capitalist investors. I understand that question. I understand that financing is probably one of the most important issues for entrepreneurs. But it's also important to know what it is, that the signal that you're trying to send. Doing a patent for the sake of creating a patent for the sake of creating a patent in and of itself is not going to be valuable to investors. Creating a good patent because you have a great idea with a great market and a great team to take it there, then that's the trifecta, right? That's the holy grail that the investors are looking for. And so while I refer to it as the icing in the cake, it's not going to be the top priority for growth if all of the other essential elements of your team are not there. However, it is good to know that patenting does actually send a positive signal to investors typically. And as you can see, that most companies that do file for patents file before round 1. But when you look at when they actually receive their money, the time to round 1 is typically more than 18 months, which means that investors are, granted, there could be other elements responsible for this time lag. But what this is intended to show is that investors wait until the patent has been published in 18 months to see that the idea is actually a good one, that there's going to be intellectual property protection there, that this team knows what they're doing, that they have a good idea, that their idea is potentially novel. And so I think that that's the signal you're really sending to investors. And they're taking that. Some investors care a ton about patents. If you're in biotech, I would be I mean, remiss to say that's a very, very important consideration for investors. If you are in tech or other industries where it's harder to patent things and it's all about agility, speed, and understanding your customers, you can copyright your code. There are other ways to protect your intellectual property investment. VCs that are generalists might not weigh your patents or your lack of patents as heavily as other factors. Overall, though, I love this concept that VCs place their bets. Whether they decide to place their bets at all has to do with the jockey, not the horse. The horse, I'd call it the product or the patent, is something that matters to them. But at the end of the day, it's really the jockey, the people behind the horse, the people getting you across the finish line, the track record for the entrepreneurs, all that good stuff. But to kind of give you some hard numbers here, there's a study that looked at somewhere around the neighborhood of 34,000 startups. And the conclusion was that those that obtain first patent approval or approval of their first patent increase their likelihood of raising venture capital investment from 6% to 9%. Whether that's entirely due to the patent or other exogenous factors, it's completely unclear what was the ultimate reason behind it. It could be that there's correlation but not causation. But I think overall takeaway is that the patents were valuable, especially in areas where there's friction, where the entrepreneurs may not have had track record of success, and the patent is kind of just additional validation and information for the venture capitalists to make the investment. However, there is a reality in that only one in three startups have patent applications rejected. So just because you file for a patent doesn't mean that it's going to be accepted. And so keep that in mind. But generally, the lack of patents is not a deal breaker, and it's just going to affect the pricing of the transaction whereby the venture capitalist is willing to invest in you. At the end of the day, you have to have an investable idea for someone to invest in your business. Intellectual property is one of many components of being investable. And as I mentioned before, venture capital and other investors consider patents as only one of many factors. Another study found that it only explained 10% of an outcome in an investment. And so if you're thinking if a patent's going to be a deal breaker or not, generally, no. But keep in mind who your audience is. Take a look at your venture capitalists, potential investors, what type of investments they've placed in the past, who they've invested in, and whether or not those investments had patents in place at the time that they had received funding. And that should be a strong signal to you as to what things that VC in particular values. And so I'm going to kind of rush through the next couple of slides because I want to be respectful of everyone's time. But this is in line with something that I said earlier, is that just because you have a patent doesn't mean that it's a valuable patent, that there has to be this ability to block others out in order to obtain value from it. Fewer than 10% of patents are even worth what it costs to secure them, and less than 50% are renewed after 11 and a half years. And what this means in reality is that for those patents that are worth less than $1 million, people aren't willing to pay anything to license them because it'll cost you just as much money. Just take them to court and sue them. By that token, the distribution of patents that are worth anywhere from $1 million to $30 million, you could typically obtain a discount licensing them, again, for these legal issues. Very few patents are these really big money patents. And so if you're looking to monetize your patents, you have to think about this in terms of, well, will an individual patent actually be very valuable for me? My sense is it's probably no. It's too hard to say with any one patent how much protection it provides and how much value you can extract from an individual patent. What this leads you then to ultimately ask is, then why do people patent at all? Well, the real value of patent comes in the portfolio of a patent. Patent portfolios are essentially a collection of patents. Think of Facebook, Google, Apple. They have thousands of patents in their arsenal that are sitting there waiting to be used, and it's that portfolio that unlocks the value. And the reason is that when you have a portfolio, you can think about it as a one super patent with coverage far greater than any individual patent. And this essentially creates a thicket of uncertainty for any competitor to navigate through. It becomes very difficult to determine whether or not you're infringing any given patent, because all that matters is that you've infringed one claim of one patent. If you have 1,000 patents collectively with 20,000 claims, suddenly you have 20,000 pieces of glass that you're tiptoeing around. And that's where it makes sense to either be very careful about releasing new products that may infringe, or to seek licenses from these individuals that have these massive patent portfolios. And to give you just an idea of how valuable these portfolios are, when Nortel went bankrupt, they sold their patent portfolio to the Rockstar Consortium, which was 6,000 patents for $4.5 billion. And so there really is a lot of value to unlock in patent portfolios. And so if obtaining a single patent with the idea of ultimately collecting a portfolio of patents as part of your strategy, then I would urge you to go that route. But if you're looking to obtain patents for the sake of patents, maybe one or two, you're not sure if you're going to use it, you're not sure if there's a market for the product you're going to sell, then I would strongly urge you to consider other options that might be more effective for you and your business. I'm going to blast through these past couple of slides here. But basically, to give you an idea of how valuable these patent portfolios are, I just want to show you this quick chart that includes forward citations and patent value. Forward citations are essentially different patents citing your patent. When I was giving the example about Dean's cup and my cup, a forward citation would be me citing Dean's patent for his red cup. But forward citations actually tell a story of both productive and destructive patent value. As the lifetime forward citations increases for certain patents, you can see that the patent value also increases. These are what are known as sparking inventions. These are inventions that create more inventions, which create more inventions. These are where real sparking innovation lies. However, you have the opposite story, which is true for the most valuable patents, because once you've created a very, very valuable patent, it's a patent that's essentially blocked everyone in your industry from practicing or innovating incrementally on your work. It's impossible to design around. And so you experience the opposite trend. You experience a decrease in forward citations, which shows that there's really strength in blocking out your competitors. And so I enjoyed this chart because I think it tells this great story of how patents contribute value and how you can observe it through forward citations. And as I mentioned, patents are typically used to block competitors, whether you're a startup, a big company, small company. They can be used to block competitors, and it can be used to innovate internally. And so you should think about these questions in your mind, like where do I see myself? What do I view myself doing with this patent? Do I want to use it just to block competitors? Am I using it as a basis to improve my own technology? What's the end game for me? So it leads to this ultimate question of, do entrepreneurs really need patents? So now we know that patents are expensive. Patents take a long time to make. Patents are most valuable in a portfolio. Patents exclude people from doing things, but don't let you do something. Do I really need a patent? And so it's no surprise at this point that it depends. You have to ask yourself all of these questions. All of these slides are going to be available for download after this discussion. And so I encourage you to go through this particular chart and think through these issues and ask yourself, okay, well, is there a market opportunity for my invention today? Is there going to be one for my invention tomorrow? At the end of the day, if you can't justify the unit economics of your product, how the heck could you justify $1 million lifetime investment in your patent? If there's no market for your invention, you have to really strongly consider as an entrepreneur, does it make sense for you to make this lifelong investment in the patent? But there are tons of considerations, and these are some of them. And I hope that you guys will think very strategically from your own vantage point as to whether or not, from a technical, market, cost, and timing perspective, obtaining a patent fits your goals. For those that decide that patents are not for you, there are alternatives, and they're known as trade secrets. Trade secrets are essentially not filing for a patent and keeping your ideas closely guarded. In fact, not all inventions qualify for a patent. And so those, if your product is one of those types of, or your key innovation is something that doesn't qualify for a patent, I would strongly consider trade secret as your route for intellectual property protection. And so trade secrets are things such as customer lists, recipes, formulas, algorithms. Another benefit of trade secrets is that they're not limited to the 20-year window as patents. The Coca-Cola formula, for example, has been held secret for over 100 years, right? And so there is some value to trade secrets. You don't have to pay anything to register your trade secrets, and you could put them in effect right away. Also, there's no guarantee that a patent's going to issue. Could you imagine your situation if you're one of those 3 entrepreneurs that files for a patent application, discloses your idea to the world, and suddenly find out that your invention cannot be patented? That's not gonna do you so well. And so trade secrets are another way to keep your invention closely guarded without disclosing publicly. The downside to trade secrets, however, is that once your idea is disclosed, anyone can use it without any recourse. And it's a lot harder to enforce trade secrets than patents. Patents have a very clear legal route available for you to sue someone. Trade secrets, you have to essentially prove that someone stole your intellectual property. And then the burden of proof is a lot higher and could potentially be costly for entrepreneurs. Additionally, trade secrets could be patented by someone else while you're in the process of selling a product that's got a trade secret in it. Someone might create a patent and sue you for infringement. And so that's another thing to be aware of. And finally, anyone can reverse engineer your trade secret by doing a teardown of your device if you're not careful about how you put your device together. So the key takeaways from today: your idea is an opportunity. It's not just an invention. Intellectual property rights exist to protect your ideas. But I would add something to that. I would say that for an entrepreneur, intellectual property rights, like patents, exist to protect valuable ideas. And so you have to think, is my idea really something that is new, innovative, creates value, so much so that it's worth waiting a few years and spending a lot of money from investors and my startup, where it's in a period where it's very crucial to be very wise about where you're spending your money. And so you have to really think about that point, I think, very critically. Patents are exclusionary rights. They do not let you do something. You have to be very thoughtful about whether or not your own inventions cover the entire product that you're trying to sell, or whether you might be infringing on someone else's patents. The best patents are those with very broad claims where no one else has done it in the past. They block large competitors and they have potential to be widely infringed. However, most patents aren't valuable, no surprise. And the best way for a company to leverage the value of patents is to collect a portfolio over time, which will create this landscape of uncertainty for your competitors to operate with. So think critically at these early stages as to whether that's the type of patent strategy you hope to pursue, one where over time you develop this arsenal of patents that you could assert against your competitors. However, you need to understand if that makes sense to begin with, because if none of your competitors have patents and all of the value is near term, meaning your company specializes in selling something that has a 3-month window for sales, and you're just rolling from every 3-month window selling a new thing, the patents might not be for you. You might want to focus all your energy on quick execution, operational efficiency, and understanding every element of your customer's needs, which you should do anyways, but these elements become far more important for certain industries where intellectual property protection through patents might not be the best path forward. And again, patents are not the most important factor driving VC funding. It's about the team. It's about the idea and execution of the idea that come first. Patents matter, but they're not the most important thing to most, or I guess to some VCs. You need to understand who your audience is. Some VCs will completely disagree with me and say patents are everything. And I'll agree in certain industries that's true, but you need to understand when that's the case and when those rules apply to you. And finally, as I just mentioned, trade secrets are an alternative to patents. And so there's more than one road to Rome. And if you find that you can keep a secret, that those in your organization can keep a secret, and potentially that your product or invention can't be patented, then a trade secret might be a useful alternative for you. And so I really appreciate everyone's time here in listening to my webinar, and hopefully you've gained a couple of juicy nuggets of information that'll help you on your way to become valuable, respected, wonderful, and more importantly, successful entrepreneurs. Thank you.
Well, Nathan, thank you so very much. I think you epitomize the MIT approach. It's systematic and incisive, as well as rigorous. That's what we took away today. We don't have a lot of time, and I know that you do have a hard stop. Can we spend?
I could go about 5 minutes over if that's okay.
So can we go for the next 10 minutes? There were a number of questions that were asked that were good. I'm going to, in fact, there are 80 questions right now, but a lot of them you already covered in the presentation. So I'll go and address some that I think were not covered in the presentation, if that's okay.
Absolutely.
So some questions are pretty simple, but the fact that an entrepreneur out there is asking the question, I think it begs an answer.
Absolutely, certainly.
So one of the questions was, can a book be a patent? And it sounds like a simple or even a silly question, but I think it's an important question because it raises the concept of public domain.
It does, but even with public domain, so there are two elements of intellectual property protection that I did not address today. They are copyright and trademark. In the United States, copyright protection is actually far more expansive than patent protection. And books, I believe, are subject to copyright protection. I guess I'm gonna be a jerk here and ask the follow-up question. Are we talking about the physical design of a book? Are we talking about a new binding mechanism by which paper or cellulose can be bound to adhesive within a strip alongside two covers? Because that is a physical, mechanical, inventive step where you can receive a patent. But the idea is embodied within a book. The execution of the ideas through a series of lines of text, that idea one would obtain copyright protection for. And copyright protection is a lot easier to obtain than intellectual property protection based on essentially having very low standards for obtaining that protection. And so a book would essentially be copyright protection. The same applies to code. When you are writing software, you can actually copyright the code that is the idea. So you take an idea and you execute a series of written steps for that idea. That text is copyrightable. And so that prevents individuals from simply copying and pasting blocks of code that you have not provided open access to.
Two follow-up questions to that. One about patenting software, but when I was talking about public domain, what I was really talking about was public disclosure. It's possible that the entrepreneur was asking, hey, if I write about my technology or my invention in a book, can it be patented after? And
in the United States, that's actually an excellent question. It used to be a trickier issue 4 or 5 years ago. The United States has changed from a first to invent to a first to file system. And the way that works is you must now file for a patent in the United States within 12 months of the first disclosure in the public domain of your idea. So you have a little bit of leeway. However, if it's been more than 1 year, it's going to be exceptionally difficult to convince the patent office that what you've disclosed to the public is not prior art. Prior art is this concept of things that are out in the public domain, whether it's through a patent or something else, that will essentially foreclose any ability to obtain intellectual property protection. So you might be your own worst enemy.
Yeah, okay. And so the second follow-up question, Anish Mahajan is asking here, can I patent a software or mobile application?
You can, to the extent that there is an inventive step there. In fact, I have it written down right here, the very clear language of what is patentable. And so I just want to make sure that I don't mince words there. But patents are granted for new and useful processes, machines, manufactured articles, compositions of matter. It must be novel, provide utility or usefulness, and must not be obvious. It cannot protect the mathematical formula, a naturally occurring substance, a law of nature, or processes done entirely with the human body. And so software is in a really tricky space after this big decision called Alice. It's not enough to just take a generic or abstract idea and put it into code. saying like software for banking, it has to have a genuinely inventive step. If, for example, it's software or an app that allows the bounce back, like Apple, when you scroll and it bounces back, there's software that does that. That is a genuinely inventive step. The software leads to something else doing something else. And so there's a very clear connection between the inventive, novelty, useful step. Code for the sake of code, or an app that is largely similar in its construction to what someone else has done, it's unlikely that you can patent that.
Thank you. Very helpful, and very helpful also because, unsurprisingly, a lot of our entrepreneurs are software entrepreneurs. So,
and those are the cases where I think being very thoughtful about what your long-term goals and short-term opportunities are, where you might not want to get a patent if it means waiting 16 months, when you can develop an app in 4 months, get it in the marketplace in 5, and be cash flow positive in a year. It might not be the best path forward for you.
Yeah. Okay. Thank you. I just want to blow through a couple more questions.
Yeah, absolutely.
So, patent trolls have caused some havoc, at least in the minds of entrepreneurs. And so we have Shalendra asking here, probably on behalf of many entrepreneurs in this audience, what are the strategies to protect against patent trolls?
I think it's manifold. First, make sure you've done this freedom to operate analysis. If you think there's a genuine concern that you might be infringing on someone's patents, you should be aware of that. You don't want to be surprised. 2, if you do find that you need intellectual property protection, obtain it. Reach out to the people that have the patents, or the organizations there's some organizations that exist solely to license patents. Pay for the patent. You're using someone else's invention. Pay for it. I think that those 2 aspects prepare you for when you do get the dreaded patent troll letter. The strategy there is I think, to fight back. It might be slightly costly in the early stages. I mean, you might end up spending $50,000 trying to get rid of this troll, but there are 2 things that are in place in addition to your own ability to fight it back. One is this new concept of fee shifting. The U.S. courts have become so fed up with patent trolls and their approaches to shaking down entrepreneurs that they've now made it possible for entrepreneurs to turn the tables on them quite easily and force the patent trolls to prove their case. And if they don't they have to pay your legal fees. And that's happened more frequently recently, where patent trolls are now afraid to sue people unless they have a legitimate case. And then 2, it's become far more difficult for the patent trolls to sue you. In the past, there was a simple 5-page form that you needed to fill out to file a patent dispute. Now it's far more rigorous. They need to make their case in clear and ascertainable ways using the claim charts that I described. And I think at that early stage, you're going to know whether or not they have a legitimate claim. If they have a legitimate claim, it's unfortunate, but the patent trolls possess a valuable asset. And sometimes, not all patent trolls are terrible. The way they go about things is certainly terrible, and they probably are picking the wrong targets if they're looking at entrepreneurs. But I think it's a question of value and understanding whether or not there's a legitimate case to be made. If there's a legitimate case to be made, that's the patent system, unfortunately. And so it's either fight fire with fire, fight fire with water, or prepare yourself and not make yourself flame retardant by essentially obtaining intellectual property protection before you're ever sued.
So we have very little time with you. I'm going to ask a question on behalf of 2 students here who've asked a very similar set of questions. It's Irina and Juan Carlos. Irina's question was, if I invented a technology before someone else patented it, or filed the patent application, I think more technically correct, do I lose the rights because they filed first? And then Juan Carlos was asking a similar question. What happens if 2 persons or organizations in 2 different countries patent a very similar idea?
So that's actually an excellent question. I think they're very different questions. I think that I'll answer the first one and try to answer the second one. Whether I answer the second one properly, I'd have to think about it a little bit. That's a great question, actually. The first question, I think it's the burden. It's related to the question you asked me about the public domain. Is it the case that the person who filed the patent application stole the idea from you? Or is it the case that they independently came up with the idea? I made the comment about trade secrets, and one of the negatives of a trade secret is holding it closely guarded, and suddenly someone else invents the same thing. That person is the inventor because your idea was not in the public domain. If that person talked to you, took the idea from you and misappropriated it, then filed for a patent, when you file for a patent, they might view the other person's work as prior art. But if you have evidence that shows that that person took the idea from you, and that evidence is completely conclusive, then they would invalidate the other individual's patents, I believe, and then you would become the inventor on it. But that's a very hard thing to show, and I would say that's the exception, not the rule. So my advice is, if you have a closely guarded idea that you want to keep to yourself, that's the risk you're taking. If you want to obtain the monopoly power that a patent affords, you have to be willing to take the risk to disclose it to the public domain. The second question, I think, is an interesting one because it's one of jurisdiction. For the most part, if we're talking Europe, United States, Brazil, they're all subject to the same patent cooperation treaties, or rather the Paris Treaty, I believe it is, which essentially allows all the different territories to rely on a patent application in a partner state as the priority date. So the person who filed for the patent in the United States that gets a United States priority date will have the inventive timestamp. Whereas if someone in France wants to file for patent through the PCT route, they might be able to file it in France, but I believe that the France National Office would look and see that there is a US priority date to that idea. And because they're subject to the same treaties, that would constitute prior art. I think it would more than anything just constitute prior art. The fact that it's filed in the domain, it's the equivalent of just not being inventive. So I think that there's a couple things that would keep that from happening. One is just the treaty, and two is just the act that you file the patent, you've created prior art.
Nathan, this is outstanding. Thank you so much. I appreciate your contribution and this incisive and very concrete analysis of this important topic that matters to entrepreneurs.
It's a pleasure. I'm happy to be here, and I can't wait to spend some time with these excited, youthful, energetic entrepreneurs in Brisbane.
Yeah. So, I hope for everyone here on the e-seminar, I can see that the numbers are still very high. Even at the end of the webinar, we have 243 people. It shows, well, Nathan, for you, it shows that, the topic really resonates and that you did an outstanding job. And I hope for you, it was a good demonstration of the kind of quality we bring to the bootcamp with coaches. These are the people that are going to be working with you on your ventures at the bootcamp. Our upcoming bootcamp, as you know, is in Brisbane, Australia in February. It is the MIT Innovation and Entrepreneurship Bootcamp. It will have some focus on sustainability, industries such as mining, such as agriculture, such as logistics. These are important sectors, but you should apply even if your interests are outside of that. But expect that you'll get to know people who are going to be entrepreneurs, innovators in the field of sustainability. The application deadline is November 1st. Apply as soon as you can. I think you will enjoy the application process. It's a highly selective process, but we think that no matter what the outcome for you, you will learn something in the process, and that's key. And no matter where this goes, we hope you will continue your learning journey with us. So apply, and one final thing I'll say, what makes a bootcamp very special is that we have people like Nathan to work with you in a very incisive way with your technologies, with your aspirations, possibly for patent strategies. And at the same time, the bootcamp is an intense team experience. You'll be working in teams. And we have people like Jocko Willing, the decorated retired US Navy SEAL, who will be working with the teams to figure out ways for you to take yourself as an individual toward high performance and to take your team toward high performance as well. So the bootcamp is a combination of people like Nathan, like Bill Olet, the professor at MIT who teaches our legendary entrepreneurship courses, and people like Jocko Willing. So we hope you will consider applying, and we thank you for being here with us. It is a big honor for us to have people from all over the world being on this learning journey with us. So thank you all so very much. Anything from you, Andrew?
No, I'm good.
Nathan, thank you so much again. And thank you.
And as Andrew mentioned, the slides and the presentation will be on the website for those that want it.
Fantastic. Thank you all. Take care.
Bye, everyone.